Thank you for the opportunity to testify on Bill 24-0110, the Criminal Record Expungement Amendment Act of 2021, and Bill 24-0063, the Second Chance Amendment Act of 2021. I'm Katerina Semyonova, Special Counsel to the Director on Policy and Legislation at the Public Defender Service for the District of Columbia. PDS strongly supports record sealing reform. The two bills pending before the committee and the newly introduced Restore Act and the reintroduced Record Accuracy Act meaningfully address the harm caused by the persistence of criminal records, of documented accusations and convictions that hinder district residents in their pursuit of education, employment, and housing. We truly believe that these bills will go a long way toward improving the lives of district residents and advancing racial equity. The current legal structure for record sealing is broken. Before the pandemic, it was typical for law enforcement to arrest about 100 people from a Saturday afternoon to Monday morning. About 30 of these arrests would be no-papered before the detained individual ever saw a judge. That means that while these individuals were processed by law enforcement and held 1 to 2 nights, by Monday morning when police presented their evidence to a prosecutor, the prosecutor decided not to bring charges against these individuals. The arrested persons are then released back to continue their lives, except that they now have arrest records. If the arrest was for what the DC Code calls an eligible misdemeanor, the person with the no-papered record must wait 2 years before they can ask a judge to seal the record of the arrest. If the arrest was for a felony or an ineligible misdemeanor, they must wait 3 years to ask a judge to seal the record of the arrest. If the arrest was for a felony or an ineligible misdemeanor and the government dismissed the case after papering, for example, on the 3rd court date, they must wait 4 years before asking a judge to seal the case. If the individual has a conviction in an entirely different matter that follows that arrest, they are subject to additional waiting periods of 5 or 10 years, depending on the severity of the conviction. These additional waiting periods apply although the non-conviction has nothing to do whatsoever with the conviction. Even after waiting for 2, 3, or 4 years, and sometimes an additional 5 or 10 years, the record sealing for that arrest is not automatic. The passage of the time periods only allows the person to file a motion to ask a judge to seal the record. Once a person files the motion, they have to wait for 4 months to 6 months and frequently up to a year for a judicial decision about whether the record should be sealed. Every day before the pandemic, people with no-paper arrests in Superior Court were given a form telling them to come to the Public Defender Service for help with record sealing. PDS has seen countless people with no-papered or dismissed cases. PDS has to tell these people that although they suffered the incredible disruption of an arrest and additional number of years, they would have to wait an additional number of years before they could go to court to ask to have a record of the arrest removed from public view. We also explain to people that they can ask a judge to have the arrest record sealed immediately if they can somehow prove their own innocence in a process that does not involve a right to counsel or a right to discovery. The thousands of people across the district with criminal records have been rightly outraged. PDS believes that reform for sealing non-convictions should have 3 main components. First, the elimination of waiting periods for all offenses. Second, an automatic process for sealing all non-convictions that does not require unrepresented people to file motions and appear in court. And 3, access to the sealed files for defense attorneys in the same manner as for law enforcement, and access for the RST themselves as needed. The waiting periods that delay record sealing for non-convictions overwhelmingly burden Black residents who face much greater rates of arrest and more abusive and discriminatory policing. People who come to PDS for help with record sealing are devastated when they learn about the waiting periods. They have immediate concerns about job loss and cannot wait years or months for sealing to occur. These waiting periods reflect an assumption of guilt. They signal a belief that although the prosecution failed to prove a single offense beyond a reasonable doubt, the shame and burden of an accusation should stay with the individual. This assumption is not fair to district residents, regardless of the nature of the allegation, and it overwhelmingly impacts Black residents who then face higher rates of joblessness and poverty. PDS also calls for a non-discretionary and automatic process for sealing all non-convictions. Under current law, a judge shall grant a motion to seal if it is in the interest of justice to do so. The determination of whether sealing is in the interest of justice includes multiple factors. Some of these factors are inaccessible to defendants. Most individuals are unrepresented in sealing proceedings because they no longer have a constitutional right to counsel once the case is dismissed. Yet they are saddled with a process that sometimes requires multiple filings and responses to government pleadings. In recognition of the fact that these criminal records come from non-convictions, the council should create a process for record sealing that it is automatic. It should require no further action by the accused, no multiple phone calls, visits to the clerk's office, multi-page motions, or waiting for judicial responses. Automatic record sealing is also well within the capacity of the court. The court already manages sealed dockets and seals convictions when they are set aside under the Youth Rehabilitation Act and seals cases under the first-time drug possession provision. Sealing the record immediately also has no impact on a decision by the prosecution to refile the case and should not serve as a justification for delaying or denying relief. If the accusation was not proven and the case was closed, the stain of that accusation should be removed immediately and automatically. One difference between the Second Chance Amendment Act of 2021 and the Restore Act is whether records should be sealed or expunged. For employment and housing, both sealing and expungement can offer meaningful relief from the damage caused by records of arrest and convictions. Sealing becomes an inferior remedy if the list of entities that will still have access to the records despite sealing becomes too long. Current law allows any court, prosecutor, law enforcement agency, licensed school, or child care provider to access sealed records. The Second Chance Amendment Act would add the entire federal government to the list of entities that can view sealed records. Adding this destroys the point of sealing the records. However, complete expungement of files may lead to other miscarriages of justice. PDS believes that it is important to allow access to arrest files for the defense for cases in which a witness's prior arrest may be relevant to later prosecutions of other individuals. For instance, the defense should be permitted to investigate and potentially expose that a witness's statement relates to that witness's own fear of arrest and prosecution for related conduct. Whatever access to sealed records is permitted to law enforcement should also be granted to the defense. And the defense should be able to ask the court for access to files sequestered there as proposed by the Restore Act. Reform of current law is also necessary with respect to convictions. Under current law, a narrow group of misdemeanors deemed eligible misdemeanors may be sealed, but only after an 8-year waiting period from the conclusion of the sentence, and only if a judge exercises their discretion to seal. Only one felony offense, failure to appear, which criminalizes missing a court date, can potentially be sealed by a judge. An individual can only seal one conviction, and it must be the most recent one. The current law means that an individual with a robbery conviction from 1975, because robbery is a felony, can never seal that record, regardless of that person's demonstrable rehabilitation. An individual with multiple convictions for misdemeanor drug possession cannot have their record sealed, even where those convictions stem from drug addiction and from a time period when the district took a more punitive approach to drug abuse. PDS supports broad sealing relief for all convictions because of the harm caused by criminal records. Expansive sealing relief is an integral part of a reentry program that advances employment, education, and housing opportunities and equity for returning citizens. PDS supports numerous aspects of the Restore Act, of how the Restore Act addresses criminal convictions, including making all offenses eligible for sealing, reducing waiting periods, and creating a presumption for sealing all offenses after 10 years. However, even if the council supports the approach of Bill 24-0063, the Second Chance Amendment Act, which directs the Criminal Code Reform Commission to study if additional offenses should be made eligible for sealing, the council should provide immediate sealing relief for all misdemeanors by passing Bill 24-0110, the Criminal Record Expungement Amendment Act. Treating all misdemeanors as eligible for sealing relief recognizes that the vast majority of these convictions were obtained without a jury trial and that they are, by definition, lower level offenses. In order to effectuate reforms for sealing relief, the council should also incorporate the reforms in Bill 24-0161, the Criminal Record Accuracy Assurance Act. The bill is forward-thinking in recognizing that many of the problems caused by criminal records stem from inaccurate reporting by private companies. PDS fully supports Bill 24-0161, and our written testimony includes 4 recommendations for that bill. PDS again thanks the council for its work on these issues and stands ready to assist the council with these reforms. Thank you.